thank you very much indeed, Mr. Chairman. I'm of course, aware that I'm in a very dangerous position. I am the last speaker between you and your dinner, so it's always a very, very risky sort of slot. But I think actually we can all agree that the pursuit of justice, especially in the wake of wrongdoing and in the face of crimes against humanity and war crimes, is one of mankind's most noble instincts. And I think it was against that backdrop that when the International Criminal Court and its stated commitment to justice without fear or favour came into being in 2002, it was embraced by a very wide range of governments, non-governmental organisations, and of course also individuals, many of whom were actually African. And I think it's fair to say that for a number of reasons the court has become actually very, very controversial. What I'd like to do right from the start, if I may, Mr. Chairman, is actually define one or two words in the title of my presentation. And I think one of the best places to start is actually justice. Justice, according to an online English language dictionary, is, and I'll quote this, the quality of being just, fairness, the principle of moral righteousness, equity, conformity to moral rightness in action or attitude, righteousness, the upholding of what is just, especially fair treatment and due reward in accordance with honour, standards, or law. Law, the administration and procedure of law, conformity to truth, fact, or sound reason. It has to be said, I think, though, right from the start, that the ICC's claim to international jurisdiction is flawed. It is not a court exercising universal jurisdiction. The United States, Russia, China, Indonesia, and Pakistan, for example, are not members. And I think the world's most populous democracy, India, is also not a member of the court. So I think at this stage in time, the court may actually represent something like 1/3 of humanity. I think also it's an accepted fact that a court is only as credible as it is independent, that the two things go hand in hand. But far from being independent and impartial, the ICC's own statute grants special prosecutorial rights of referral and deferral to the United Nations Security Council, which is actually perhaps the world's most political body. And of course, by default, to its 5 permanent members. And I think one of the earlier speakers touched on the fact that you have a situation where a permanent 5 at the UN Security Council, 3 of whose members are not actually members of the International Criminal Court, have been referring other members, other member states who themselves are also not members of the ICC, have never signed the ICC treaty, to the ICC. So, I mean, apart from violating, I think, and contradicting sort of international treaty law, I mean, obviously a country cannot be bound by a treaty it has not signed. I think many of us may also agree that this is neither actually fair or just. And I think at the end of the day, at the very least, it's an example of a democratic deficit, because obviously the citizens of Sudan and Libya have never been party to that decision process. The International Criminal Court is a European Union child. The only debate is whether it's actually by conception or by adoption. The court is linked inextricably to the European Union, which actually provides over 60% of its funding. The EU, in turn, is actually, interestingly enough, guilty of blatant political and economic blackmail in tying aid for developing and emergent nations to ICC membership. So if you are a country in Africa, if you are one of the weaker countries in Africa, if you do not agree to join the ICC, you will not receive your quota of EU assistance, actually financially and economically. A clear premise of the court, as enshrined in the Rome Statute, is justice for all, equity and moral righteousness. These values have been very hard to discern, very hard to find in the court's record to date. What is clear is that the ICC has ignored all European or Western human rights abuses in conflicts such as Afghanistan and Iraq, or human rights abuses by Western client states, those states that actually are friendly or have been of use to the various Western governments. One example, which is actually sort of very, very black and white, is in Afghanistan, which of course is a ICC member state. Any civilian death related to war crimes, or that might be war crimes related, in Afghanistan is subject to the ICC. And of course, most of the NATO member states who are involved in that conflict are also themselves members of the ICC. The ICC has done absolutely nothing with regards to the tens of thousands of deaths of civilians as a result of NATO action or NATO inaction in some cases. But there's actually one specific example where in September 2009, a German colonel was actually responsible for the deaths, actually the burning alive, of over 100 Afghan civilians in Kunduz. He actually went ahead with that action in direct violation of every single NATO standing order as to how to call in airstrikes and how to actually take control of an action. A number of German ministers in the government had to resign. However, the ICC and the German government did nothing with respect to that colonel. In fact, he was actually promoted to general and has actually carried on in his career. That's actually one example amongst dozens of examples of just what's happening in Afghanistan alone. So instead of impartially enforcing the Rome Statute without fear or favour, the Europeans have in fact actually are chosen to focus almost exclusively, in fact exclusively, on Africa. The International Criminal Court is self-evidently a racist court in that it only treats, or it treats one race of people differently to all others. This is neither fair nor just. Imagine the uproar in the countries where you come from if there was a court in your country that said, we will only actually prosecute black Africans, despite any other crimes actually committed by anyone else within that country. That would actually be greeted with outrage and uproar. But that's exactly what the ICC has been party to. It's actually received almost 9,000 formal complaints, written complaints, registered complaints about alleged war crimes and crimes against humanity in at least 139 countries. Of that, the ICC has actually chosen to indict 36 black African people within 8 African countries. Now, many of the people who actually have been subjected actually to this, I think, have also articulated a certain déjà vu, because the very countries that actually direct the ICC are also almost exactly the same countries that were European colonial powers on their continent. So in many ways, I think it's almost sort of unarguable that the ICC has, in fact, emerged as an instrument of European foreign policy, and its actions are being seen increasingly as some sort of recolonization by legal diktat. Of course, it's amazing at a time when political correctness has actually permeated so much of Western culture that the global North has actually turned a blind eye into this behavior that actually amounts to racism when it comes actually to the ICC. Now, of course, this is also a state of affairs which the United States are very happy to go along with. Washington has actually forcibly pointed out on occasion after occasion that the ICC is a kangaroo court. It is a travesty. It is a political court without any competence, and that no American citizen will ever appear before the ICC. At the same time, it's actually insisting that black Africans appear before the exact court they have actually demonized themselves. Why? Well, because it actually serves a number of objectives that can only be seen as being political. Procedurally, in terms of how the court itself has actually functioned on a day-to-day basis, it has become, the ICC has become a study in competence. The proceedings have been questionable where they haven't been simply farcical. So many of its judges are people who were appointed without any legal experience whatsoever. They've never been lawyers, let alone judges in their own other own countries. They have been elected as the result of vote trading between certain member states of the ICC and certain regional blocs. And of course, actually, far from securing the best legal minds in the world, which you would actually hope was the case for a court like the ICC, what that actually produces is mediocrity. Vote trading across the board in any institution results in mediocrity. So you have mediocre individuals who have never been lawyers, who are now appointed as full ICC judges, and they're meant to be deciding on, in some cases, the most intricate aspects of international law. You actually had one judge who was appointed because her country had given the ICC a huge amount of money in 2009. She had no legal degree, she had no training. Her only asset was that she spoke English, which was actually one of the languages of the court. So it's, you know, as a result of that lack of legal experience, you also had instances where halfway through a trial, the judges decided to add new charges halfway through the trial. Now, there may be lawyers amongst you. I mean, that's one of the most outrageous abuses of any legal system. That was eventually overturned on appeal some months later, but it cost weeks and months of waiting and delay in that particular trial. And you also have had the case of the ICC Chief Prosecutor, who was not just seemingly unaware of the concept of presumption of innocence, but when somebody came up against him in New York and said, well, I think that one of the people you have indicted, who has been indicted but not tried, might be innocent, the Chief Prosecutor said, well, just in saying that, I think you've actually committed a war crime. So if you argue that Mr. A might not be guilty of the charge which he's been indicted and not tried for, the Chief Prosecutor said that itself may well be a crime. So, I mean, I'm not exactly sure which world we're living in, but it sounds like a sentence first and verdict afterwards. It's a sort of a rewrite from Alice in Wonderland. You also had sort of the instance where in the first ever trial, the showcase, a trial of the ICC, where the Chief Prosecutor, the same man, was actually found to have hidden hundreds of items of exculpatory evidence that might prove that the defendant was actually innocent. And he'd actually hidden this not just from the defense, but also from the bench. Which again, I mean, is within any sort of Western legal system, that prosecutor would have been actually disbarred and probably actually prosecuted. Now, of course, there was, the ICC being a mechanism so all of its own, there's an appeal system also for the prosecution. So both the defense and prosecution can actually make an appeal. And for some reason, the appeal which the prosecutor actually lodged against that, the decision then of the judge to actually abandon the trial was overturned on appeal. So these are just one or two of the examples of widespread legal procedural incompetence. You've also had instances where the prosecution, again, specifically in the main case, but in fact throughout all the cases, have actually produced witnesses who recanted their testimony the moment they got into the witness box. The second they got into the witness box. I think one of our friends earlier mentioned the case of Thomas Lubanga, the first ever trial of the ICC, which is actually still ongoing. It's now, I think, 6 or 7 years. The judges right at the end of that trial, although they actually somehow managed to find Mr. Lubanga guilty, said that every one of the child soldiers who were produced as witnesses on the charge of actually him having used child soldiers, with the exception of one of them, every one of the witnesses was found not to have been credible. And these, again, were witnesses actually produced by the prosecution. So 90% of their witnesses in that case were deemed not to have been credible witnesses. And you've had this happen actually this week in the Kenyatta trial. Witness after witness is actually falling out, saying we were bribed by the prosecution, I want to actually recant my evidence. They offered me huge amounts of money and to be resettled in Europe. So these are just actually one or two of the things. The ICC also, of course, actually came into being and promised to be economical and to bring swift justice. So far, it's actually consumed 1 billion euros since 2002, and its first case is still in the appeal stage. Its first case is still, it may have actually had, I think, now 2 guilty verdicts, none of which have actually ended the appeal stage as yet. So this is also one more example of many of the abuses that's seemingly actually built into the actual system itself. Now, what I'd like to touch on again also is, very briefly, is whether the ICC itself can be described as an adjunct to regime change. Now, adjunct is defined as contributing to or aiding an activity or process in a minor way, being supplementary or in a subordinate relationship. Within that definition, it's very clear that the ICC served as an adjunct to regime change. And one clear example of that was Libya in 2011. Now, as many of you may know here, in March 2011, led by France and the United Kingdom, NATO, sort of 28 member states of NATO, went to war against Libya to overthrow the government of Colonel Gaddafi. And the war, of course, in Libya ended in late October 2011, actually following the overthrow of that regime and Mr. Gaddafi's execution. The ICC's role in that its intervention is very, very clear. In mid-February 2011, following on from events in Tunisia and Egypt, there was unrest in parts of eastern Libya. The process escalated, and the Libyan government responded firmly, which resulted in civilian casualties. Western governments, though, at that stage realized that the government would not be overthrown, in effect, by the Libyan people. And a British parliamentarian at the time used the gambling analogy to describe the Western approach to Libya immediately after that. He said that Britain has gambled, I'm quoting from him, Britain has gambled on the Libyan issue. We bet on it all being over in 48 hours. This did not happen, and when this did not happen, we doubled the bet and then doubled it and doubled it again, end quote. Now, one of the poker chips, the gambling chips that was actually thrown onto the table by NATO was the ICC. On the 26th of February 2011, the UN Security Council referred the situation in Libya to the ICC. On the 3rd of March 2011, after just 4 days, the ICC prosecutor declared that he would open an investigation into the situation. These referrals usually take months, if not years. Within 4 days, he jumped at the invitation. So on March the 17th, 2011, the Security Council passed a resolution which imposed a no-fly zone on Libyan airspace. Russia and China, for whatever reason, actually acquiesced to this. NATO took charge of the operation and 2 days later commenced bombing Libya. NATO then, of course, unilaterally extended the no-fly zone into a no-fly zone, no drive zone, no sail zone, no Libyan military zone, within which Western air forces then began to attack Libyan government forces on the ground, on site, on air, land, and and on the sea. Now, NATO basically began acting as an air force for several Islamist militias actually fighting against Libyan government forces. Now, of course, it's actually worth noting that the Libyans actually began to actually continue their resistance actually to these NATO attacks. Again, one more of the gambling chips actually thrown in. And on the 15th of May, the ICC prosecutor then said that he had already concluded his investigation and that he was almost ready for trial. He then applied to the ICC judges for indictments. And, of course, the ICC indictments followed within a matter of days. Now, the speed at which the ICC responded to the NATO, in effect, the NATO request for indictments was staggering. And I'll just, one quick quote, a quote from Louise Arbour, who is one of the sort of friends of the ICC. She's a former UN High Commissioner for Human Rights. She's involved in both of the Rwanda and Yugoslavian tribunals. And even she was amazed at this, the speed. And I'll quote her, "The Libya referral is noteworthy for the speed with which it was made. In the case of Darfur, it took 2 years before the UN Security Council made its referral. Another 2 months will pass before the ICC formally opened its investigation. In comparison, the Libyan process has so far progressed at great speed. The decision to refer the situation to the ICC was taken less than 2 weeks after Gaddafi's crackdown began, and without waiting for the results of a UN Human Rights Council inquiry announced just the day before. The speed of this response is unprecedented. It normally takes months for a preliminary investigation to be concluded. In this case, it took only 4 days." My last quote is actually from Michael Ignatieff, who I'm sure many of you know is a noted Canadian human rights expert, and also expert on the whole concept of the responsibility to protect. And he said, again I quote him, "The unresolvable question is whether the ICC indictment played a part, inadvertently or not, in driving the Libyan operation beyond its original mandate of actually protecting civilians into full-scale regime change." These are two quotations from people who are friends of the ICC, not cynics, not critics, fully paid up friends of the ICC. The reality is that much of the International Criminal Court's 13-year existence to date has had little to do with justice. The ICC has emerged as a political court that has actually hitherto only served to further the interests of the global north, and especially European foreign policy, at the expense of the global south. And in conclusion, my concern is that this court will soon be focused on Ukraine and events in Ukraine, where again it will actually do nothing more than serve the interests of the European Union and the broader West. Thank you.